Never put your kids' names on your house deed to avoid probate. Do this instead. If your main goal is to keep your house out of the probate court when you pass away, listen very carefully to this warning. Never put your kids on the house deed to avoid probate. It sounds smart, simple, zero cost, shortcut, right? Just add your son or daughter as joint tenancy with rights of survivorship, and when you die, the house automatically belongs to them. No court, no lawyers, no hassles, except it is one of the single most dangerous estate planning traps in existence. By trying to save a few $100s on the probate court, you could easily trigger a tax bill worth tens and thousands of dollars. You could also expose your house to someone else's debt or even be forced out of your own property. Today, I'm going to walk you through 3 hidden landmines of putting your kids on the deed today. And then I will show you the 2 right ways to skip probate, keep 100% control of your home, and protect your family in the process. When you go down to the county recorder's office and add your child to the deed joint owner with rights of survivorship while you're alive, you aren't just planning for the future, you're giving away immediate legal ownership today. The moment their name goes on that document, they legally own half of your home. And in that instance, it exposes you to 3 massive risks. Risk number 1, their debt becomes your debt. Let's say you put your son on the deed and 2 years from now, he gets into a serious car accident and gets sued, or his business fails, or he files for bankruptcy. Or maybe he goes through a bitter divorce. Because his name is on that property, his creditors or his ex-spouse can place a legal lien against your home. You could be forced to sell a house to pay off debt you had absolutely nothing to do with. Risk number 2, you lose complete control. Once their name is on the deed, you can no longer sell, refinance, take equity out of the loan without their explicit written permission. If you decide you want to downsize to an apartment at the age of 80 and your child refuses to sign the paperwork, you're stuck and you cannot sell your own home. The only way out of that situation is doing a partition lawsuit where you actually sue your son in the court, because you can't force somebody in the state of Georgia to own a home. So then there's another lawsuit just so you can sell your house. Risk number 3, family disputes. If you have more than one child, but you only put one child on the deed for convenience, that child becomes the sole legal owner when you die. They are under no legal obligation to split the money with their brothers or their sisters, no matter what you ask them to do with it verbally. This can tear families apart every single day. Now, let's say that your kids are financially responsible and never get sued and love each other dearly, and putting them on the deed while you're alive can trigger a financial disaster called capital gains tax trap. To understand this, you need to understand a term called step-up in basis. Let's use some real numbers. Imagine you bought your home 30 years ago for $100,000, and today, thanks to the market growth, that home is now worth $500,000. That is a $400,000 worth of taxable profit. So let's take scenario A, which is the wrong way. You give half your child the house by putting them on the deed while you're living. In the eyes of the IRS, when you give that 50% interest during your lifetime, your child retains the original cost basis on half of the property. That means they forfeit the step-up in tax basis on half of the property's value. So when you pass away and they go to sell the home for $500,000, they could easily end up facing capital gains on $200,000 profit that could have been completely tax-free. In Georgia, they will get half step-up in basis. So if it's $400,000, it's taxable. Like, they would get the step-up basis in value for the parent who passed away, but they still are on the hook between the value of what they have and the new step-up basis, they could easily end up facing a capital gains on $200,000 profit that could have been completely tax-free. Now, how that works is you would get half step-up in basis for the parent side. So it would be added to the original basis that they got while you were alive, the $500,000. So their new basis would be around $300,000, and they would get taxed on that $200,000. And depending on where you fall in the tax bracket, for federal, it could be anywhere from 15 to 20% of that amount. And for Georgia, I think that is roughly around 5.19. And I think it kind of can vary too, depending on where you fall in the tax bracket. So that's a big chunk of money. Scenario B, the right way. You keep full ownership while living and transfer the house to them only upon death using the proper estate planning tools. When they inherit the house right after your passing, the IRS applies step-up in basis to 100% of the property. The cost basis resets from $100,000 all the way up to that $500,000 market value. Your child turns around within the next year and sells that house for $500,000. Their taxable gain could potentially be $0. They pay $0 in capital gains. So by not putting them on the deed today, you literally avoid handing over thousands of dollars to the government for no good reason. So how can you actually avoid probate without falling into these traps? You have two main tools here in the state of Georgia, depending on your situation. So option one is a transfer upon death deed. Now, if you lived here in Georgia, this is a massive deal. For decades, Georgia didn't allow for transfer upon death deeds for real estate. So if you spoke with an attorney years ago, they probably told you a trust was the only choice. Georgia officially legalized the transfer upon death deeds around July of 2024. And when it was originally passed, they had a strict 9-month deadline where your child had to file paperwork within 9 months of passing or the whole deed would fail and it would go straight into probate right away. Fortunately, in the spring of 2026, our Georgia state legislature updated the law and completely removed that 9-month deadline, along with making it clear on who's in charge of the property, making it a much safer, cleaner, and far easier for Georgia families. So think of Georgia's transfer from a death deed like a beneficiary designated on your bank account or a life insurance policy, but for real estate. Here's how it works. First, you record the deed today that names your child or children as the beneficiary only upon your death. Second, while you are alive, your child has zero ownership interest. Their creditors can't touch the home. They have no say in what you do. You can sell, refinance, do whatever you want. Third, you can revoke or change the beneficiary at any time. So if somebody gets a little nasty and you want them to write out of your will or out of your estate plan, you can do so without asking their permission. Fourth, when you pass away, the house transfers to them automatically, completely bypassing the probate court while they preserve the 100% of that step up in tax basis. A Georgia transfer upon death deed is very affordable, simple to execute, and ideal if your primary asset is your main home. Option two, a revocable living trust. Now, while Georgia's transfer upon death deed is a fantastic tool for simple situations, a revocable living trust is still absolutely the gold standard for real estate planning. Here's why. A trust goes several steps beyond a simple deed. First, total privacy. Probate court proceedings are public records. Anyone could look up an asset that you've owned and who inherited them. Even deeds recorded in the court are public, but a revocable living trust is completely private. It never goes through the court system. Your trustee simply uses the private trust documents to execute and transfer quietly behind closed doors. Second, it has an incapacitation protection. You serve as your own trustee while you are healthy and maintaining 100% control. But what happens when you develop dementia or suffer from stroke or become incapacitated? With a simple transfer upon death deed and a simple will, your family might have to go to court for an expensive conservatorship just to pay your bills. With a living trust, you name backup trustees who can step in seamlessly and manage or sell the property for your care without ever stepping into a courtroom. Third, control beyond death. A trust allows you to set specific rules, like holding on to funds until minor children reach a certain age, managing blending family dynamics to protect assets from future divorces. So while Georgia's transfer upon death deed, it gets the basic job done, a living trust gives you privacy, incapacity planning, and total legal protection. And if you own more than one property, you definitely need to have future planning around that. Maybe create LLCs around investment properties and tie them up into the trust as well. So to wrap this up in a nice little bow, you do not have to put your kids on your house deed today just to avoid probate court tomorrow. The risks of lawsuit, loss control, and massive capital gains are far too high, in my opinion. Instead, talk to a estate planning attorney, and if you don't know one here in Georgia, I could connect you to a few, about setting up a transfer upon death deed or a revocable living trust. You'll keep control today, save your kids a fortune in taxes tomorrow, and ensure that the home passes down smoothly. If you found this video, please hit that like button. It really helps out on our algorithm. And tell other people here in Georgia, homeowners, send this to them who might need to know this information. Subscribe for more straightforward real estate and wealth protection strategies. And let me know in the comments, have you set up a transfer upon death deed or trust here in Georgia yet? Thank you for watching. And if you enjoyed it, maybe you'll enjoy the next video. See you later. Bye.